Hello, everyone, and welcome to another live stream session with ImmigrationQuestion.com. We're glad to have you here today. My name is Chanel Ford, and I'll be your host for today's session. Today's topic, emergency relief in immigration court, bond hearings and stays of removal, is not only timely, but also essential. Whether you're an immigration advocate, a concerned family member, or in proceedings yourself, today's discussion will assist in shedding light on what you can do when the stakes are highest. To help us navigate this critical topic, we're thrilled to welcome a phenomenal professional in the field. She was born in Puerto Rico to a Puerto Rican father and Venezuelan mother. She brings over 15 years of immigration law experience to the table. She's earned her JD from the Pennsylvania State University Dickinson School of Law after graduating summa cum laude from the University of Miami. Her practice also involves a general array of immigration concerns like cancellation of removal, asylum, adjustment of status, family and employment-based cases, and professional visas. Welcome with me, Attorney Isadora Velazquez. Welcome to the show, Attorney Velazquez. How are you today?
I'm doing very, very well. I'm very happy to be with you guys today discussing, as you mentioned, something very important to discuss in this environment that we're living right now.
For sure. To all of our viewers on all platforms, get ready because it's about to get exciting. Get your pencils and your notepads and let's dive right in. Okay, our first question. When someone is detained, their first question is usually, can I get a bond? Or can I get out on bond, really? Attorney Isadora, please, could you walk us through what a bond hearing is and how one can request one in immigration court?
Of course, to address, as you mentioned, the first question of can we get a bond, I would say the first question is where am I? Where am I going to go? So when you are detained, you may want to find out where you're going to be located, and it may take a while to be processed. And that will be my first warning to anyone. Hopefully, you're never detained, but if you are, know that the rights that you may see on TV or that may apply to U.S. citizens, the whole 24 hours before a judge or to be processed, sadly may not apply to immigrants. It may take a week or so before you appear in the system in some cases. There's a specific website in which you will show up, and then you'll know where you're being processed, as we call it, where you're going to be detained, where you're going to be held up. And that's important to answer the Chanel's question as to whether you qualify for a bond or not, because that will be where you will file your bond. In some places, if you file your bond and you're later transferred, the judge who may be in that place may say, I no longer have jurisdiction, and you have to start all over again. So it's important to know where you're going to be to file the bond or not. Some people will not qualify for bonds. If you are what we call an arriving alien, meaning you were detained at the airport, so I'm very sorry, but you won't qualify for the regular bond before a judge. You will have to ask for a specific bond that we like to call specific parole with ICE directly. And I must warn you that in this environment, we're not seeing many of them granted, but you can always try. And that's for arriving aliens, applies for people detained at the airport. The other category of people who will not receive a bond would be individuals who are detained for controlled substances. You were smoking a joint back in 1995 and you received a conviction, and now they decided to arrest you for it for immigration purposes. It may seem trivial, but that specific conviction may be placing you on deportation. And if that's the case, the controlled substance, and you may be detained for it and you won't qualify for bond. Other crimes that won't qualify for bond would include any sentence that is more than 1 year in jail, and that may also include house arrest. So there are specific circumstances that you can try your best, but if your house arrest was over a year or you spent over a year in jail, you may not qualify for a bond. All other cases, you may qualify for bond. You just have to show ties to the country and that you're not a flight risk, meaning that you're not going to be running away. The government's always going to fight against it. So it's good to show how long have you been in the US? Who do you know here? Who can support you? Who can vouch for you? It's always essential to have a sponsor, somebody who will say, I will show up for court. I'll make sure that you don't run away, that I will pay for this bond, that I will accompany you to court, and that at the very least I'll be responsible for you. So if you have those details, try for the bond. But once again, I hope you never have to go through this.
Fingers crossed. Let's dive deeper into timing. You brought that up, and I think that's really good. For individuals who are facing imminent removal, a stay of removal can be like an 11th hour lifeline, right? Can you walk us through how and when one can request a stay of removal and what factors are considered in whether or not this is granted?
For imminent deportation, the response is immediately. If you know you are detained and you're going to be removed, a stay of removal needs to be filed right away. It's very important to know where to file it, and that would be your local ICE office. The local office, if you can go personally, would be best. After COVID, we have better access to submit things online and to mail them, but that's the best way to, I wouldn't say prevent, because nowadays we can't really guarantee anything, but at the very least try. However, nowadays you can be proactive. If you already know, for example, that you have a removal order that could make you subject to deportation eventually, and you want to take proactive steps, there's some states of removal that you can file proactively. For example, if you were deported in absentia, those are deportations that happened when you were not present. Maybe you had an accident on your way to court. Maybe they gave you the wrong court notice. Maybe you were sent to the wrong address. Many things could happen that could justify why you didn't go to court. Don't wait. Now would be the time to file a stay of removal. Instead of waiting for the immediate threat of deportation, you can be proactive and file what we call a motion to reopen, explaining what happened, why didn't you go to court, and for that specific type of deportation in absentia, that would be tied to a stay of removal, meaning that if ICE were to knock on your door and try to take you away, send you back, you would be, at least there's an attempt to protect you while the motion to reopen is pending. So stays of removal should be filed as soon as possible if you know it's imminent deportation, but there's some that could be filed preemptively tied to other motions depending on your circumstances. So look them up. Definitely explore your options.
Thank you. Um, one thing that I let me not say think one thing that I've observed that usually leaves individuals a little perplexed or confused is the understanding of how judges make their decisions, right? What in your experience are some of the most significant factors immigration judges evaluate when determining whether or not to grant emergency relief?
Emergency relief is mainly tied to the ties that you have to your country, to the United States. I've noticed that judges, particularly, you need to distinguish between what is a bond motion, which would be something that the judge would be the one determining, and they'll want to see why wouldn't you run away? Why won't you go into hiding? What do you have to lose? So if you have a family in the United States, if you have a sponsor that is sticking his neck out, that is putting his name there, that is paying for this instead of a bondsman, for example, something that is significant, something at play, they consider that in issuing a bond because they think you're not a flight risk. They will always consider your criminal history. Of course, if you have a criminal record and the more severe it is, the less chances you will have of receiving a bond, but you can balance it by how much of a life have you developed in the United States. And the same would apply for the stay of deportation. The stay of deportation, the comments that we received from ICE officers who are the ones that process these stays of deportation is that now they're receiving the same amount of stay of deportations as they are receiving, as they used to receive the request for paroles back during the Biden administration. As some of you may know, parole requests were sent back then because people were maybe coming in through the border and they wanted to change their status to say they were coming in legally. You had to do so by sending a request to ICE. So now they're receiving these requests asking for, please let me stay, although I have a deportation order. And they're considering the same things judges would consider in a bond motion. They're considering what are your ties to the country? Why should you stay? How long have you been at your job? What family do you have here? Are you married? Do you have children? How are you studying? What are your grades? So these are your day-to-day activities that you may want to magnify to show that you are tied to the United States so that they can see that you're actually an asset to this country and that you can't go back home, that you should be allowed an opportunity to fight your immigration case while you're here in the United States.
Love it. Thank you so much for your tips thus far. Let's dive deeper into business. We're living in some high pressure moments, let's be real. What do you recommend lawyers or any real litigants to do to make an effort and for like an effective case for emergency relief?
When it comes to lawyers, for us, the main thing is to ask many personal questions. We need to inquire and really get to know our clients. What I've noticed is I find it very uncomfortable in my cases when the judge is asking a client a question to a client and I'm finding out the answer for the first time. And it is uncomfortable sometimes to discuss maybe family, especially because many of the ties that we immigrants may have in the United States may be ties that are also undocumented, and we want to protect them. We don't want to mention that we are married to somebody who doesn't have status, that our children don't have status, that our friends don't have status. But it is necessary for attorneys to ask those uncomfortable questions, particularly the questions on how you ended up there, because nowadays we have seen many cases in which maybe there were things that were already litigated, at least that's what I've noticed, and are happening again. Sadly, the same way I started by mentioning that immigrants don't have the 24 hours to appear before a judge that we see in U.S. citizens, same thing has been occurring with double jeopardy. We have seen cases that have been resolved and now are opening up again. And this is not new. In 2017, during the prior Trump administration, we saw many cases that maybe were administratively closed. These were cases that were put on pause in the immigration court and then were later reopened. But now we're seeing cases, particularly in the bond side, in which bond was granted, people were out preparing their case for a final individual hearing, and now they may later be picked up on the same reasons they were originally picked up back in the day when bond was granted. So attorneys have to inquire and sometimes understand that when the client tells us, I don't really know why I was picked up, it may be true, which for us as attorneys is baffling. This is something unique that we hadn't seen before, but it is happening. So ask uncomfortable questions and understand that these are completely new, unprecedented times, as cliche as it may sound, in which we may have to advocate things again and let the judge know this is not the first time we are bringing this issue up. It's unique. This is not something that we usually argue, but we may have to do so over and over again because it's what's happening.
Thank you. Thank you.
Thank you.
To our amazing audience, thank you for joining us. If you're just tuning in from any social media platform, this is attorney Isadora Velazquez that we have based out of Miami currently. She's a seasoned immigration attorney who has contributed significantly to today's topic. This is immigrationquestion.com, a platform designed to simplify the immigration process. Ask your immigration questions for free in any language and get connected with a verified attorney who can offer legal guidance. You may also receive a free, confidential initial consultation. Visit www.immigrationquestion.com and sign up today. Very quickly, Attorney Velasquez, for a platform that seeks to aid the immigration journey of every documented and undocumented immigrant by connecting them with seasoned immigration attorneys just like yourself, what do you think of immigrationquestion.com and what we do for the immigrant community?
I think it's very helpful because right now what we're seeing is a lot of disinformation and a lot of fear. So it's helpful when you're informed, you may lose some of the fear, you may feel more empowered. Please ignore my puppy in the background. She likes to jump in from time to time and play with her toys. But it's
No
good.
worries.
And knowledge gives you power. So the fact that you guys are providing that knowledge is very helpful to immigrants and to immigrant allies. So I hope that you can continue doing so. That knowledge definitely essential to feel protected in these unprecedented times.
Definitely. Thank you for that. And I would just want to echo what you're saying. Knowledge truly is power. Like that's the best first step that you can get, right? Is just getting some clear understanding and some knowledge. Thank you so much for that. Before we jump into the live Q&A session, I've got one more question for you. One thing our readers are likely to ask is, what can families do to prepare? Are there any proactive steps that families or communities can take in advance in a case that in case a loved one is suddenly detained or finds themselves in a precarious situation?
Know your case. I've noticed many cases that we try to be like an ostrich. We pretend that if we are not aware of what happened in that old case that I had in 1995, or if I don't know what happened when I came in with my mom and dad, it's not a big deal. I've been here for a long time. Nothing's going to happen. Then when it does happen, I'm scrambling to find out what's my status. What happened? I thought I was a U.S. citizen, or I thought I was a resident. I thought I had status. Know your case. It may require discussing with a family member. Have a copy of your file. Maybe your case was old. Maybe your attorney died. That's how long these cases are being reopened now. That's how long they're being considered. So if you have lost your file, you can always request a Freedom of Information Act request. That's a FOIA, we call it. It's very important for you to have a copy of your file, review it. These cases are complicated. So maybe pay an attorney a little bit for their time and have them review it and have them explain what happened with that case. Am I good? Do I have a deportation order? Should I reopen my case? Ask these questions. I am aware that immigration law is expensive. It's not like criminal law in which we have access to public defenders, but it is worth it to know our case and be ready now instead of when we are later approached by an ICE officer and we're scrambling to stay in the country. So know our case, know what happened, start gathering records of what you're doing in the US. Oh, these are my pay stubs. I'm gonna have a little file here with all my pay stubs, all my taxes. I'm gonna have some pictures here, maybe a box of pictures that I'm just going to save. Some of my friends who love me, I'm not asking them to write reference letters now, but let them know that just in case this is my status, this is my situation. If I need you, don't be surprised if I one day call you. Not just for now, in the future, hopefully, if you don't have status, you may want to adjust. It's good to have that friend, that boss, that colleague that you can reach out to who will write that reference letter for you to get your green card. So start preparing, don't wait till the last minute, and understand your situation so it's never a surprise.
Thanks. I love it. Thank you so much for just all your insight and knowledge today. It's been really, really helpful. And now, audience, it's your turn. You can type your questions into the chat box and they'll definitely appear, or you can give us a call directly at our number. It's right up here, 516-703-3483. Again, that's 516-703-3483. We've got our first question. Looks like it's from Sadia. My brother was arrested by ICE last night and now he's in detention. When can we ask for a bond hearing?
Sadia, the first thing is to know where is your brother. If you already know the detention center where your brother is located, then you can send the bond hearing request immediately. Meaning if that detention center has a court, which most detention centers do, you can hire an attorney and have them send the bond request immediately. That's the main thing, because once you know where your brother is, that means that your brother has been processed. I say this because in the detainee locator for ICE, if your brother shows up, that means he has already been processed. Big difference if maybe your brother called you and said, I am here, but he doesn't show up. That means he's still not processed. He could be transferred. Sending the bond hearing there might be useless because we don't know. It might be rejected. But as soon as you know where he is, that's when you can send the bond request. Make sure it's properly prepared, meaning that the bond request include it. I hope you have status, so that way you can say, I am the sibling, I am a U.S. citizen, I am a U.S. resident, I have enough funds. Include evidence of the funds and the relationship that you have with your brother, and that you can be the sponsor, that your brother has been in the U.S. for a certain amount of time, how he entered in the country. If you know why he was detained, maybe he was driving without a license, maybe he wasn't doing anything except just standing in front of his house and I simply noticed that he was undocumented. Try to explain as much as you can, and send it right away. And the reason I emphasize sending it right away is because once the person is in a location and they have bond, it is less likely that they'll be transferred. And what we've noticed is the longer you take to request the bond, the more likely a person may be transferred from that location to another, which may be further away, Louisiana, New Mexico, Arizona, Miami. So it's good to be proactive and send your bond request as soon as possible.
Thanks. Our next question comes from Patrick. If someone doesn't have any family in the U.S., will it be hard for them to get a bond?
In all candor, yes, it will be difficult, but not impossible. The reality is the law requires, well, the law will consider the ties that you have with the U.S. The ties don't necessarily have to be family ties. The ties could be friends, it could be your job, it could be the creation of your own company, it could be the employment that you provide. So although family is a great tie that judges definitely consider, and it is very significant, it is not the only tie. So make sure you include all the ties so that we can show a full picture and give the person the best chance.
Thanks. Let's see what's next. From Demetrius. How can we prove to the judge that my wife isn't a flight risk for a bond hearing?
show that your wife has never committed a crime before. And if maybe there has been any instances in which she has been forced to go to court before, that she has always shown up, that she has never fled the justice system, that she has lived at a specific place for a certain amount of time. How long has she lived at each location? Has she moved a lot? How long has she owned the same property? If she is consistent with the same job, being consistent in the same location, that's how you show that you're not a flight risk. You have the same friends. You're a pillar to your community. You have the same circle. If you're a person that moves regularly every 2, 3 weeks, that might be difficult. But if you've been living in the same place for a month, 2, 10 years, then that's where it becomes significant. And that's where you can show I'm not a flight risk because I've been at the same house for 10 years, filing my taxes with the same friends at the same job. I'm not going anywhere.
Yes. Thanks. From Ms. Tura, is there any emergency way to stop deportation if someone's child has special needs?
Yes. Find the ICE office closest to where the child is located, the address where the child was detained or the address that ICE may have for them. You must file a stay of deportation quickly with all the medical records, particularly the medical records that show that the child is being treated in the United States. You can mention in the stay of deportation that the child cannot be deported or should not be deported, should not be removed because the medical treatment that they have received for the entire life or majority of their life, or the medical treatment that has been most significant for their health, has been in the United States. The medical records are essential. Of course, the more you have, the better. Even if you think it's significant, even if you don't understand it, include it. But it's at the very least you can get a letter from their main healthcare physician. That should be enough to at least file it as soon as possible so that they know this child is being treated here and that they know the child's condition, because sometimes special needs are not visible and they don't understand them. So it's good to inform them and do so as soon as possible at the local ICE office of the person who has been detained.
Very useful information. Jimenez, can I still file stay of removal when my deportation is already scheduled?
Yes, yes, you can. That's the point of the stay of deportation. Typically, when deportations are scheduled, they don't tell us. That has been a very common scare tactic recently, to tell us that deportation has been scheduled simply for us to give up or to sign our own voluntary departure and have more control and to simply deport ourselves. But if you have been told that their deportation is imminent, or you already have a deportation order, you know that it's already scheduled, you still, until it happens, you can always file a stay of deportation. As I've tried to reiterate during the show, it's important to do so as soon as possible because that also gives you a chance to follow up. You want to be able to call your deportation officer and ask him, hey, Johnny, have you received this? I sent it to you yesterday. It has my daughter's drawings explaining how sad she will be that if I am deported, to emphasize to them why you should stay. So you still have a chance, definitely file it. And if you have time, try to follow up.
Thank you. Dolores, if my child is a U.S. citizen and I am not, does that help in court at all?
Yes, it helps very much so, because when your child turns 21, your child will have the privilege of petitioning for you to stay with them. The problem is that will only happen when the child is 21. However, it's a very legitimate argument right now to say that you have significant ties to the US and that you have a legal remedy, meaning a way to acquire your status in the country legally when the time comes. So it is definitely something that you should let the court know. It is also something that should motivate everyone to have a close relationship with their child, because the court will want to see that. They'll want to see that you are involved in your child's life. Simply providing information of the child is not enough in most cases. They'll want to go beyond just the birth certificate. They'll want to see that you, beyond also child support payments. They'll want to see pictures of your child. If your child can attend the court hearings, I know it may be traumatic sometimes, especially in detention centers when they may have to see you dressed in a certain manner. But the reality is that judges do appreciate some judges appreciate seeing the family and the unity and the support that they may bring you. You may also appreciate seeing your child there in this stressful moment. So yes, having a child who's a U.S. citizen, even if you're not, is definitely very helpful in all these court proceedings, something judges want to see, and they want to see your involvement in your child's life.
That might have been our last question. Okay. Thank you all. Okay, cool. Thank you so much for joining us today, Attorney Velazquez. Thank you, thank you, thank you. That brings us to the end of today's webinar. Thank you for sharing your knowledge, your clarity. Thank you for having compassion. It was really great to connect with you today. If anyone's missed any part of this, you can feel free to watch the replay on Spotify by searching for Borderless Talk by immigrationquestion.com. Join us next week for another insightful conversation. Any exit information or anything that you want to throw out there before we go?
To not give up. I know these times are stressful, as we mentioned many times before, but there's definitely hope. Just have to be informed. Keep listening to podcasts like this. Make yourself informed as to your rights. There might be few rights for immigrants, but you definitely have rights. Use them. Fight for your rights, and you'll make sure to have a happy ending in the non-bad way, in the way that you actually deserve.
Thank you so much. Have a great day, everyone. We'll see you next